Welcome back. A former Rhodes University student is not backing down in the fight against her academic exclusion. Yolanda Dyanti was banned from life for being at the forefront of anti-rape protests in April in 2016. She's now challenging a High Court ruling that upheld her expulsion and exclusion, saying findings of the independent disciplinary hearing were irrational. Let's now speak to her representative, Nomzamo Zondo, who's the executive director at the Socio-Economic Rights Institute of South Africa. Nomzamo, good afternoon. Thank you for your time. What arguments did you guys put forward when you approached the High Court initially to challenge the outcome of the disciplinary hearing?
Good afternoon. So, Seri, on behalf of Yolanda, approached the High Court arguing that Yolanda should at the very least been given an opportunity to defend herself against the serious charges that were levied by Rhodes. That the proctor who chaired the disciplinary hearing should not have postponed the disciplinary hearing to a date when Yolanda's legal representatives are not available. We also argue that what the very least what he should have done is weighed up the prejudice to Yolanda against the prejudice to the university and given reasons for why he would not postpone it to a date when Yolanda's advocates were available. And so when we brought the review application, we complained about this. We also complained that the chair was reasonably suspected of being biased. And when we approached on Monday, we approached the High Court, who has refused to set aside the disciplinary hearing outcome. We argued there that the court should have considered whether Yolanda had a right to legal representation, especially because at the time that the matter was postponed, she had been represented by these two advocates for over 3 months. The matter is quite complex. There have been many witnesses, and at the very next sitting, Yolanda was expected to lead her case, to give her testimony. And we felt that it would not be fair it wouldn't have been fair for the proctor to expect Yolanda to show up without that legal representation.
What have been the implications of the High Court ruling that upheld Yolanda's lifetime exclusion from Rhodes University?
Look, it means that Yolanda's struggle continues because for Yolanda, she has consistently requested her day in court. She has consistently requested that she be given the rights that are available to every accused person, that the rights that the university gives to other students in her position to give her side of the story. We were quite disappointed. Yolanda was disappointed that in March of this year, the High Court in Grahamstown refused to set aside the disciplinary hearing outcome because we felt that there is a clear right to be heard in such proceedings. In fact, as a country, even where people are said to have committed offenses or where there's clear evidence, people are given the opportunity to tell their side of the story. We don't understand why it's different for Yolanda and why she should simply have her future taken away from her without being allowed to defend herself.
But is she allowed to enroll in other institutions? What are the terms of her expulsion?
So she's been excluded for a lifetime by Rhodes. Immediately after Yolanda tried to apply to other universities, in fact, she was one of 2 students who were excluded, and all the universities sang the similar song, that the exclusion from Rhodes means that she can't enroll in any other South African university.
So what's the plan now? What are you going to be arguing when you appeal the High Court's decision?
Our argument is very simple, that Yolanda has a right to be heard, that the disciplinary hearing, the proctor, the chair of the disciplinary hearing, should not have postponed the disciplinary hearing to a date when her counsel was unavailable. She was, because of the seriousness of the charges, entitled to be legally represented, by the team that she had chosen and was available to her. And that as a country, and I think even the university would accept, that the right to procedural fairness is guaranteed to all students, including Yolanda. And we hope that if we are given leave to appeal by the Grahamstown High Court, when we make that argument before the Supreme Court of Appeal in Bloemfontein, the court would agree that the university should set aside the disciplinary hearing and give Yolanda the opportunity to tell her side of the story.
All right. Nomzamo Zondo, thank you so much for your time. Executive Director at the Socio-Economic Rights Institute.